Conduct. So unethical acts and misconduct are two important points. So chapter 7 talks about misconduct. What they said is misconduct. The following act of commission or omission of the part of the patient shall constitute professional misconduct in rendering him. So they said that all the violations should be considered as misconduct. What they said violation? She does not maintain medical record. If medical record is not maintained, not kept for 3 years, not been given in 72 hours. So when patient demand and you refuse to give within 72 hours, then it will be treated as misconduct. So you cannot refuse a relative if they want a medical record of a patient, but it should be a blood relation preferably or attendant, because confidential and privacy also comes in the picture. Patient, yes, you need to. She did not display the registration number accorded to him by the State Medical Council or a Medical Council of India in his clinic prescription certificate. On every document, you need to have a registration number. And I've got a case only because of this where prescription of a doctor was not having a registration number. If you don't have a registration number, then again it is a violation of a law. Adultery or improper conduct. Naturally, it has been logged. You cannot do improper conduct. You cannot do adultery. That is definitely going to disrespect the community, and it is said to be an unethical act. Conviction by the court of law. In any case, let it be PCPNDT, let it be 304A or 304, or moral turpitude is not being welcomed by medical council, and suo motu action for unethical and misconduct can be taken. Sex determination, very broadly seen in the country after PCD PNDT Act has been seriously been launched, MTP Act, if not been properly followed, then yes, in such a cases also my doctor can be troubled under the regulation 2000. Signing professional certificate report as a document, very categorically clearly mentioned under the law. The registered medical practices are in certain cases bound by the law to give or may for time being called upon to give a certificate, notification, report, the document similar character by them in their professional capacity. I'll give an example. Many of the time, police officer do call a doctor to declare a death, because once death is declared, they can send it for the postmortem in a very criminal case. You may be called sometime, or your client may be called sometime. Explain it. Not to worry, you're legally bound to give a certificate. You can't oppose that. Only thing is that you examine the patient, mention who called you, like this is to certify that Mr. So and so, the body in front of me having identification mark, or Mr. So and so, name given by the police officer. After I've been called by this police officer, number so and so, and a designation so and so. After examination, now found PP is not recordable, pulse not recordable, RR not recordable. In my opinion, body in front of him is a death declaration, not cause. So many of the time you've been called and you need to give, and like many other places. So wherever you've been called and legally required, you need to. Registered practitioners should not contravene the provision of Drugs and Cosmetic Act, prescribing psychotropic drugs where no absolute medical conditions are indicated. And this was very seriously taken in multiple judgment where the people have argued only on the basis of the prescription given by the doctor, supporting evidence that it was not indicated, but doctors prescribed same treatment, which is very common. We need to prove that why we have prescribed the steroid or why we have prescribed this. So for the steroid, many of the people have gone to the medical council that this drug was not required, or this drug was prescribed and leading to impotency or leading to some other problem. So naturally, 7.8 comes under that. So we need to be very careful. Schedule L drug rules need to be followed of drugs and cosmetics. Performing or enabling unqualified person to perform an abortion or illegal operation for which. So naturally, where the surgical indication is not there and you are doing some surgery, then it is going to be problem. And then you should not have assistant who is non-qualified and doing everything. Like, majority of hospital unqualified nurses are doing a delivery, and where the death leaded to death, yes, my doctor are going to be definitely liable under the regulation 2000. A registered practitioner shall not issue a certificate of efficiency in modern medicine of unqualified non-medical person. They can give to nurses, they can give to paramedical staff, but they should see that, but they cannot give a certificate to unqualified people or untrained people. A physician should not contribute to lay press articles or give interviews regarding the disease or treatment. So many of the time you see lots of newspaper are highlighting the article of the doctor. But if the article is not clearing, it is only for education purpose, it's okay. But anywhere, if at all it looks to be that soliciting a patient or soliciting a practice, then it also can be suo motu taken by the medical council under the regulation of the code. An institution run by the physician for the particular purpose, such as maternity home, nursing home, private hospital, rehabilitation center, or any type of training institution, may be advertised in the lay press, but such advertisement should not contain anything more than the name of the institution, type of patient, type of training. So they have restricted every institute for giving advertisement which lure the patient. It is improper for the institution to use usually large signboard. So they have defined the signboard also. The very big signboard with all lightings and all definitely can also be troublesome for my doctor. So they have defined that how all this should be, how the things need to be. It is improper to affix signboard on a chemist shop. So you cannot put a signboard on a chemist shop also. The registered medical shall not disclose the secret of a patient that have been learned in exercise of his professional capacity, except to the court or of notified disease. So, as I said, confidentiality and privacy plays a vital role. So they can only disclose it to authorities, not to any other person. Practitioners should not refuse on religious ground to treat the patient. So they need to treat every patient. Very clearly mentioned that every operation, doctor must take a written consent of husband or wife, parent or guardian in case of minor, of patient himself in case of his case may be. In an operation which may result in sterility, the consent of both husband and wife is needed. And this comes multiple times in your medical law practice that wife or doctor will call that wife as abandoned by husband, or wife says that husband is in Dubai or some other foreign country, cannot come and she become pregnant. And doing the extramarital affair, lots of issues come where female alone come for the MTP, married woman. And then question comes and question will definitely come to you. In what way I can do MTP? My friend, these are the laws, but woman can take the cause for herself. She can alone give a consent in a criminal law. It is okay. But ethical practice, definitely you need to create some evidence so that tomorrow your doctor can defend if at all they are doing MTP in a page. A registered medical practice shall not publish photograph or a case report of his patient without his permission. So they cannot, you cannot put in journal and other things and all. In case of running a nursing home and applying assistant to help him, the ultimate responsibility, naturally, it is very true that for all the staffs, you are going to be responsible. You should not use an agent and tout, which is common practice in the country. Even rickshaw driver has been given a cut to bring a patient. So you need to avoid all this thing. You should not claim to be a specialist unless you have got such special qualification. So nowadays in the country, in a cosmetic domain, we have found that every specialty wanted to do a cosmetic practice. And the question comes, many of the time we have seen the cross specialty practice. So these are going to be unethical acts. No act of IVF or artificial shall be undertaken without informed consent of female. So naturally, female, her spouse, donors, everyone, and now ART Act has already seen a color in this country. IVF industry is already regulated by Surrogacy Act. So naturally, this has been widely described under that we need to follow. We need to follow clinical drug trial to ICMR guidelines, which is mandatory. They have added to regulate the doctors to practice in rural area after completion that course. That is also said to be unethical act. So widely decided, widely defined under the act. If you see the whole act of chapter 6 and 7, every aspect of medical practice is very well controlled by medical council. So it is a wider aspect. Everything, whatever you do, everything has been considered. So many of the time, which is not mentioned under the act, also been given a power to this committee to take a suo motu action or extend their jurisdiction. Like medical negligence, they have not talked about medical negligence under the chapter 6 and 7, but the power is given to the committee to use their discretion power, which is not mentioned in this, and add on anything which they feel it is unethical or it is misconduct. And that is well clearly been defined in chapter 8. What they said, it must be clearly understood that instance of offense and professional misconduct which are given above do not constitute and are not intended to constitute a complete list. Very beautifully they have worded it. Okay, above all, which was given chapter 7, 1 to 7, cannot be said to be complete list of the infamous act which caused the discrimination. And that by issuing this notice, Medical Council of India or State Medical are no way to preclude from considering any and dealing with any other form of professionalism. So, which is not mentioned under 7 chapters. But yet, the council feel that this is misconduct or this is unethical. They also can, widening their jurisdiction can include that. That the reason medical negligence has been included under it. Very clearly mentioned that any form is considered a part of registered medical. Circumstances may and do arise from time to time in relation to which there may occur a question of professional medical which do not come within any of these categories. Every care should be taken that the code is not violated in a letter or a spirit. In such instance, as in all others, Medical Council of India, State Medical Council have considered and decided upon the facts brought before the Medical Council. So they have been given huge power to look to the matter. What 8.2 said? It made it clear that any complaint with regard to professional can be brought before appropriate medical council disciplinary committee. Upon receipt of any complaint, the appropriate medical council hold an inquiry, hold an inquiry, and they can hold the inquiry and give the opportunity to registered medical patient to heard in a person by pleader, in person or by pleader. So now try to understand this word. The procedure we have already seen in every aspect. Now let's see the medical council's procedure. Medical council's procedure very clearly says that when complaint comes to the medical council need to give opportunity to respondent, could be a doctor, to reply on that. Okay, these are the allegations put forth to you, and doctor need to reply. Not only reply with evidences, with written argument, with the argument, but also can be accompanied by authorized representative or by pleader. So they have given a power to whom? In person or by pleader. Now, pleader means authorized representative also. So either doctor can alone go or pleaded by authorized representative or pleaded by advocate. So both are in. So even if you're not an advocate, you also can appear as authorized representative to protect and safeguard doctor. But now let me tell you one more thing. The new NMC regulation 2023 has blocked that. If it comes as it is, then they have stopped authorized representative and pleader altogether. But let this act come because that need to be interpreted in a right spirit. But here they have allowed either in person or by plead. If the medical president found the guilty of committing professional misconduct, the appropriate medical council may award such punishment if necessary and may direct the removal of altogether or specified period from the register. Deletion from the register shall widely be published on local press as well as in the public. So what is the punishment? Procedure is very clear. Complaint once comes, the copy is given to the doctor. Doctor need to reply. Evidence both party can produce, and then written argument and argument. If punishment is given, punishment will be in the form of warning that please don't repeat, or second suspension for some time period, could be 1 day, could be 7 days, could be 1 month, and third removal of name from the register, which is next to impossible. Because next to why I say because you will not find any people who have been removed from the register. It is like a professional death penalty. It needs a very serious matter only where professional death penalty can, and it can be published in newspaper. So that is the worry point of the doctor. In case of the punishment of removal from the register is from limited period, that is 1 day, 7 days, 10 days. Appropriate council may also direct that name so removed shall be restored. So once 1 month is over, your name will be restored. That is what is the decision on complaint against delinquent patient shall be taken within limitation of 6 months. So time limitation given to decide any matter is 6 months by medical council. During pendency of a complaint, appropriate counsel may restrain patient from performing procedure. Yes, interim relief can be given where during the pendency also doctor can be stopped to do their practice, which is normally not been followed because it is going to be a conviction prior to the trial. So it is not very widely been observed. In a few cases, I definitely observed where suspension was given during the pendency of a trial, but not in all cases.